Hello everyone, and welcome to your week 6 Monday morning breakfast bite. Today we start talking about intellectual property. And intellectual property refers to personal property that is of an intangible, what we call an intangible nature, because you're looking at a property right as opposed to something that you can necessarily touch and feel, like a computer or a book or a chair or a couch or a, whatever, refrigerator. Those are things that you can feel and you can touch, and those are tangible objects of personal property. Intangible, though, has to do with those things that we can't necessarily touch and feel. Then intellectual property rights falls within that idea of intangible personal property. So we'll be talking about that this week, and also note that your midterm opens this week on Thursday and closes on Sunday night. So you want to make sure that you take it somewhere in that time frame. It's 50 questions, multiple choice and true-false questions, and it covers everything that we have reviewed or discussed over the past 6 weeks, including this week's material. So it's important to pay attention to this week's material as well. So when we talk about intellectual property rights, I'm just going to quickly pop up. Don't forget to do your Module 6 assigned readings and videos. Just go ahead and pull this up real quick. Just so I can give you a basic breakdown. So when you look at the PowerPoint, which is coming what we're doing is we're looking at 3 primary types of intellectual property, but there's also trade dress and trade secrets. So let's identify all of the categories of what we consider intellectual property, and those are trademarks, service marks, which fall within trademarks as well, copyrights, patents, and trade secrets. Now, trade secrets in the past were actually a creature of state law, but now there is federal law regarding trade secret protection. But we're starting off with just the general understanding of intellectual property, and as I stated, the fact that it is an intangible personal property right. So we start with copyrights. And copyrights, as we all know, many of us think about movies, you think about songs, you think about books, and those are all things that are subject to copyright protection. But to have a statutory protection of a copyright, you actually have to file your copyright with the Patent and Trademark with the Copyright Office. And after you do file it, then you have a statutory right. The good thing about that statutory right is it gives you payment of your attorney's fees and cost if in fact you find that someone is infringing that copyright. Not necessarily true with a common law copyright claim. Now, the Copyright Act of 1976 governed the items that you see listed in red on this screen. Literary works, musical works, dramatic works, pantomimes, which we don't think about, but choreographic works, which dance moves, pictorial, graphic, and sculptural works, motion pictures, any audiovisual works, any sound recordings, and even architectural works. So architectural plans actually are subject to copyright. But really, virtually anything that we do that we put down into a tangible medium of expression is subject to our ability to have it protected under our copyright laws. Now, something very important happened in 1978, and that was the Sonny Bono Copyright Extension Act. Now, for those of you that don't know anything about Sonny Bono, the Sonny and Cher duo, Sonny was a songwriter and producer, manager, and Cher was his wife, and Cher's very famous singer. But he ended up becoming a U.S. legislator, and senator, when he did, he pushed for extension of copyright protection. Because it used to be the author's life plus 50 years. So they extended it by 20 years to the author's life plus 70 years. Now, for commercial works, it's 100 years. And right now, Disney is actually fighting that and trying to get that changed because some of its caricatures and cartoons and things of that nature are coming off of that protection, and they're really looking to make sure that that stays protected. So when you go through everything this week, pay attention to the cases that I have cited, because those cases kind of reiterate and reinforce the learning objectives and the things that you need to know for the intellectual property that we're studying this week. The fair use doctrine is very important to know. Understand that the character of the use, the nature of the material, those things come into play when someone is trying to apply the fair use doctrine, which is actually a defense to copyright infringement. Then there are some additional doctrines, the first sale doctrine, the public domain doctrine. Pay attention to those things. And then after a while, obviously, when we came into our e-commerce stage, our cyber stage, where everything started going online, we needed different protections. So that brought in the Digital Millennium Copyright Act, which is also known as the DMCA. So pay attention to that area, and then we start talking about patents. Now, patents are different from trademarks because even though you're patenting something that's written down, you're actually patenting the idea once it is, again, reduced to a tangible medium of expression where someone can understand what it is the person wants to patent. But the patent is a very different intellectual property right than that of a copyright. So take a look at those items. Make sure you pay attention to the readings with regard to that as well. I just want to make sure that we're covering everything and that we're not missing anything. Remedies for any intellectual property violation are going to include the items that are listed on this screen in red. Equitable, damages, and attorney's fees. So equitable is if somebody is violating your copyright or your patent, then you're going to want to restrain them from doing that. So you're going to want the court to issue an injunction. Now we also have to look at what are the damages that resulted as from, in fact, my copyright or my patent being violated. And if I have a statutory right because I filed properly, then am I entitled to attorney's fees, which does happen in some cases. Now, I'll also talk about trademarks, and there are 5 categories of trademarks, only 2 of which receive automatic protection, and those 2 are arbitrary and fanciful. Next page defines those different categories, so you want to pay attention to that and understand that a trademark is different from a copyright. Look at the lap factors, or aka sleek factors, because those identify what a court has to determine in order to say trademark infringement did or did not occur. Okay, and then we have the Federal Trademark Dilution Act to pay attention to those items as well. And then we have service marks and trade dress, so be aware of those. And that's all, folks. So you have a great week 6. If you have any questions, please don't hesitate to contact your instructor. And don't forget, your midterm opens on Thursday, closes on Sunday. So good luck, everyone.